Welcome to one and all. I do hope that you're all comfortable and that your kids don't use all your bandwidth while you're online. Just really wanting to set the scene. I'm a practitioner as well, same as the rest of you. And basically, I'm dealing with all the same issues as all of you are. What we're looking to do at the moment is to give the best general advice as to how to work through these issues as we go. So what we can't do is deal with every individual circumstance. It's just not possible. Just to give you a bit of a background, since the property law section guidance went out last week, Kim Bull, the manager of the property law section, and myself are receiving more than 100 emails a day. So for those of you who haven't had a reply, that's why. Today we have about 2,500 of you viewing this. So if all of you start writing in with your scenarios, it's simply not going to work. So today is all about general principles, looking to apply those and how we can move forward. I just really want to set the scene by saying, how did we get here and what has happened and what has happened so quickly? The reality is, this is unique. It's on a worldwide scale. Everyone is scrambling for the best solution, for the most equitable result, for the best outcomes for all of our clients. And many of those outcomes are in conflict. We get that. There's no how-to manual. It affects everyone in some degree. No one will come out unscathed. There are fiscal impacts for everyone. Our clients, we have some clients in desperate financial situations already. This has exacerbated the position for them. We have to be sympathetic to that. But on every conveyancing deal, there are at least two parties on each side, and there are impacts for everyone. We're working through and evolving our recommendations in line with government recommendations and working with departments to try and resolve things as quickly as we can. There aren't any answers. There are some overseas cases that maybe touch on a few of the points, but there is nothing absolutely on point. We are looking to commission expert opinions as we go to try and give some of those answers. I just want to have a recap of the past week, which has been, it would be an understatement to say it's been stressful for all of us. The actions that we've already taken include ongoing communications with government departments. And I must say, I am extremely heartened to see the receptiveness of the various government departments and agencies to work with Law Society and with Property Law Section around achieving the best outcomes. And that is an ongoing work in progress. Robbie Muir will talk more about the relaxed LINS requirements on witnessing. DIA has made concessions around delayed client due diligence. Any of those of you who've been dealing with DIA will know that's no mean feat. NZLS guidance on administration of oaths and declarations. We have the barrister opinion from Paul Collins, who has indicated a process and procedure for remote witnessing of statutory declarations that is available on the New Zealand Law Society website. The other key one that we're receiving a lot of inquiry around, enduring powers of attorney and wills. As you're aware, those are regulated by statute. Any one of you who's been involved in changing laws or making submissions, typically the process to change a law takes months to years. We're already in discussion with the government departments, MOJ, Ministry of Justice, around what possible options there are, whether that be during lockdown, during level 4 alert. We don't know, but we're still working with those. So that is going on behind the scenes. Interim guidance from Property Law Section. Again, you've seen that last week. So that's just really everything that's happened in the space of 1 week, which is absolutely incredible that we've been able to coordinate with government departments, come out with some changes already, ongoing discussion. I really want to hand over to Robbie just for his opening comments. Robbie, floor is yours.
Look, thank you, Duncan, and again, morena, everyone, and welcome to this this webinar, and thank you very much for joining us. Look, I just really wanted to echo Duncan's comments. You know, recognizing the challenging circumstances that we're all in as a result of the COVID-19 lockdown. It's really critical that all of us are understanding and kind towards one another, and really need to accept that there will be some things that won't be possible until alert levels are reduced and things return to some semblance of normality. But having said that, you know, I think everyone's been very focused on how can we make things work in terms of work that it's still possible to continue with. So with that in mind, certainly at LINZ, we've been very deliberate about reviewing our regulatory requirements and making adjustments to our processes so that people who are able to work remotely can continue doing their conveyancing work where it's feasible to do so. And I'd just like to also say that we very much appreciate the collaboration and cooperation with the New Zealand Law Society Property Law Section, Duncan and the team around these matters. It's made all of this a whole lot more doable, having that existing relationship and being able to work so well together on these things. So look, that's all I wanted to say by way of opening comments, and I'll just hand back over to Duncan.
Thank you, Robbie. Just one other comment I want to make is around questions. We've already received over 100 questions. So obviously for today's session, we will not be able to address all of those. What I would ask is that you perhaps keep the questions coming during the course of the session. However, we are hopeful that we have a good feel for what many of the situations are, many of the scenarios, and hopefully most of those will be addressed during the course of the presentation. So perhaps if you can, wait and see if your answer is given in the course of the presentation before you start clicking away on that keyboard. Settlements. That is the key issue for all of us. I've heard figures of around 5,800 settlements are affected during this 4 week of lockdown. One of the myths that I really want to bust right off the top is there seems to have been a rumor, hopefully quashed, that said all settlements are on hold during alert level 4 lockdown. Property law section's never said that, Law Society has never said that. So let's debunk that myth here and now. It's all about cooperation, talking to the other side. Another interesting one that's come up is I'm hearing stories where lawyers have taken it upon themselves to negotiate what's happening on a deferral without actually referencing to their client. Seems an obvious thing to do, but in panicked and stressed situations, I do believe that some are forgetting the fundamentals. Talk to your client first. Client may want to proceed, and there are a number of scenarios where it's perfectly legitimate to proceed to settlement. We'll talk about that in subsequent slides. Many parties have adopted the property law section 10 working day deferral. Now, I hasten to acknowledge, and this is an obvious one that we did discuss around the executive table, is if everyone wants to move that 10th working day after we come out of level 5, there's simply not enough movers to do it. We get that. But in the interest of having a baseline or an indication as somewhere to start from, We decided to keep it simple and put the recommendation out last week. So don't necessarily think that has to be the default. Work among your clients, see what works best for them. It may well be some want to extend for 15, 20 working days. I've got some that we're working on that at the moment, and that is going to work best for all parties. So it's not about that, oh, let's just jump to that default. It is look to reach the best fit agreement for everyone, and that will require compromise. It is not about contractual rights. Many of our clients are saying, what's my contractual right? What is my legal right? That's the wrong question. It really is, what are the consequences of me insisting on my strict legal right? That needs to be borne in mind, and we'll talk about that going forward in subsequent slides. So it's about us being professional, being advisors, and counselling our clients in this unique situation, because the contract doesn't contemplate the current circumstances. Tenanted properties. If you have a tenanted property where the tenant is remaining, there's no reason that that can't proceed. Some vendors and purchasers, of course, are demanding settlement. Some have already jumped to the move of issuing settlement notices. And I think that's probably quite harsh in the circumstances, and we'll talk about that in a couple of slides' time. So it's more about bigger picture effect on all the parties concerned. The contract I'm referencing is the 10th edition ADLS agreement. Most of us will be on that, some may be on older versions. If we have a look at clause 3.3, definition of settlement there, or the process of settlement, shall be given and taken on the settlement date. There's much debate around if the ability to take possession means you don't have to settle. There are differing views, and I'm not going to give a specific view on it other than to say the effect of not taking possession legally may not necessarily mean physical occupation of the premises. Possession may mean the right to that possession. The effect of not being able to give possession, absolutely, that's a biggie if someone can't move in. There are numerous arrangements. Some have elected to say, okay, purchaser will go ahead and settle the purchase and allow the resident vendor to continue on a rental basis. That said, it should not be an opportunity to extort that party with some unrealistic, exorbitant rent. Again, it's about reasonableness. So no two settlements, no two scenarios are the same. It's about looking at the bigger picture. Does the purchaser want to? Is the purchaser still in a position to go ahead with that settlement? Is it possible to negotiate with the vendor to carry on in there on a rental basis? Think about those questions. Ask the client. Talk to the other side. The other interesting one is clause 3.15. And that is the scenario where neither is ready, willing, and able to settle. So both are in a predicament where they can't settle. Whether that's the situation now, if neither party can move in or move out, still a question. That contemplated a deferral to the third working day after one of the parties is able to settle. I only put that in there as an example of a contemplated deferral where there are inabilities to settle. We had an hour-long meeting with the executive yesterday, Property Law Section Executive, which, as many of you will be aware, comprises 10 property experts from around the country, from varying size firms to sole practices to large corporate firms. Property Law Section has resolved to seek a barrister specialist opinion on the issue of taking possession, and if that is a barrier to actually, or a reason to give to not settle. So I want you to just think about some of those points, but talk to your clients, think about what is practical in their situation, what works best for them. Common scenario that seems to be an area of dispute is the vendor says, right, property's vacant, I don't care, my contractual right is to insist on the purchaser settling, don't care about their predicament. Contractually, yeah, they probably can. And the Law Society cannot rewrite the terms of a binding contract. All we can do is make recommendations to how to resolve a situation. So let's have a look at some of the factors that arise. Pre-settlement inspection. Some are saying, can't do a pre-settlement inspection. Does that entitle me to not settle? Interesting point. There may be certain circumstances where works were to be done and they were substantial and a pre-settlement inspection was needed to ensure they were done. Other circumstances, the house may have been vacant since the contract was signed. Again, think about the circumstances. I also would like to remind everyone about the non-merger clause 12 of the agreement. Rights are not lost. Rights are not lost if there is a problem post-settlement and post-possession. You've still got rights of recourse under the non-merger clause 12. Keys. Numerous scenarios. Some of the questions that have come in have talked about, well, okay, the keys are in a lockbox on the property, no physical handover required. Again, we come back to the point, well, technically, is the purchaser allowed to go to the property? Do they technically have possession notionally because they've settled but can't physically take possession of it, as in move in and take occupation? Again, these are questions we need to get expert opinions on to formulate and pass on to you. In the meantime, talk to your clients, see what works best for you, see what works best for the other side. I mean, if we come back to the fundamentals of why are we in this predicament? What's the cause? Obviously, COVID-19. What is the effect? The key effect that is causing all of this is the prohibition of movement of people. If we didn't have that restriction, we probably wouldn't be having this webinar. So think about it fundamentally from the point of view of if things can still happen without the movement of people, then it should probably proceed. Purchase of a rented tenanted property, a vacant section. Yes, I hear you, vacant section, but my clients are reliant upon the money from the sale of their house to pay for the section. I get that. Again, it's about individual circumstances. If your client cannot, because of other circumstances, engage with the other side, explain the situation. And I've had it where some clients are asking for something, the other side says no. I explain their personal circumstances. Person on the other side says, oh, yes, I get it. Let's defer. There's been some discussion around whether moving house is a permitted exception, an essential service. It is not. A week ago, we all got the state of emergency alert that said, where you stay tonight is where you must stay from now on. There were already the level for movement restrictions imposed. Police reiterated that, as has Ministry of Health. So I think it is very clear, and I don't think there's any argument there that moving house is acceptable. There was still debate last week. I think this week there is not so much. But fundamentally think about, does the settlement require movement of people? Can you negotiate it so that it doesn't require it, i.e. vendor remains in the property on a rental basis? Think about options. Does your client want to go to court? Those of you who have had your clients involved in civil litigation will probably know the answer. Even clients that win say the stress, the time, the emotional toll it's taken, even though they win, they lost. So I do think to say, oh, we'll issue a settlement notice and we'll see you in court is not the way forward in this situation. So please talk to your client, talk to the other side, and there will need to be give and take on both sides. Let's have a look at the vendor who is detrimentally affected, who is insisting and sometimes bullying the purchaser into settling. Does the vendor really want to cancel? Who knows what the market will be in the future? Likely resale? Price going forward? Yes, I hear those of you saying, okay, we can sue for that difference on resale. Not if the person doesn't have any money at the end of the day. And again, litigation, which I don't think your clients want to do. Vendors should be able to get mortgage payment holidays. I've had one situation with one of my clients, vendor, vacant property, talk to the purchaser, can they settle? No, for a number of reasons. Fine, my client accepted a deferral in accordance with the guidelines and has negotiated with the bank, and obviously the government has been talking to all the main lenders about that mortgage repayment holiday. So my client isn't paying a mortgage, and okay, sure, rates and insurance, negligible in the circumstances. So it's about probably looking at the bigger picture for your vendor client who wants to insist on their strict legal rights. One of the other ones that I really wanted to talk about where there's a dispute, interest rate for late settlement. Interest rate for late settlement is essentially a penalty. The amounts run anything from 12 to 15%. That's intended as a penalty. The current situation we're in is essentially as a result of a force majeure. It's a no-fault situation. Because of that, it is suggested, and some of people are already adopting this, to talk to the other side about, hey guys, we don't know which way this is going to fall. Down the track, a vendor who thinks they were right may not have been, and vice versa, a purchaser who thought they were right, insisting on their strict legal rights, may be found to have got it wrong. So to hedge bets and to minimize and mitigate potential losses for both sides, what many are agreeing to do is halve that interest rate for late settlement. Not saying you have to, not saying you can force anyone to do that, but I think it is a really smart move to hedge your bets to make sure that if you get it wrong for your client, that it is a less of a fiscal impact. So I just put that out there for you to consider. And again, I come back to the point of no two settlements, no two situations are the same. Work through with your client what the impact is going to be and how it will work for them and their situation. The other interesting one that I almost regret having put out last week was reference to anything in alert level 4 not being a working day. That was really putting out the thinking, part of the thinking and rationale as to fairness, etc., from the executive. I had a number of calls and emails saying, Duncan, on what do you base this? Where's your authority? We don't have authority for it other than looking forward as to what courts may consider was appropriate. Some may say banks are still in operation. So a working day, non-working day typically was around availability of banking. Again, we have a unique situation. Who knows where this would go? Interestingly, there are some overseas jurisdictions that have made reference to anything during our equivalent of level 4 lockdown is not a working day for the purpose of some statutes, some agreements. I'm not saying that will be the case here. Who knows? Watch this space. But it is certainly a risk, and that is why I'm saying to people, think about at least negotiating down that interest rate for late settlement. The other one that I was somewhat reluctant to tackle, and either stupid or brave or both, is commercial leases. We've been receiving quite a few inquiries around this, and I guess one thing that's come out of COVID-19 is we are extremely familiar now with the terms and conditions of the 10th edition agreement sale and purchase, and now more so the terms of the ADLS commercial lease. Obviously, the one that is front of mind is 27.5. If we have a look at the mischief contemplated by that clause, it arose from the Christchurch earthquakes, where commercial tenants were unable to physically access their premises due to the red zone blockade. Basically, military there, blockade, you can't enter. Landlords saying, hey, nothing wrong with the building, it's not damaged, so continue to pay the rent. So this was really about what legal access is. So it's not on all fours, but it seems to be certainly an arguable case that 27.5 does apply to the current situation to some extent. Can the tenant legally access the premises? Again, this is about movement of people. Pharmacy, medical supply, you may say, okay, my tenant is a pharmacist, they're open, they can access, so why should there be any rent abatement? Cafe, restaurant, hospitality, etc. No. Key words that are being focused on in that clause are a fair proportion. Isn't that extremely subjective? What's fair for the landlord may not be fair for the tenant, and vice versa. There are a huge number of divergent views from one extreme to the other, as in full abatement versus no abatement whatsoever. Again, I come back to it. Do you really want to wait and be in court? The delay, the cost, the stress of that. My best advice at the moment, and I'm doing this for my both landlord and commercial client tenants, is negotiate, negotiate, negotiate. It is far better to have an agreement going forward to know where everyone stands than to have a Mexican standoff and wait for the court to decide, which may result in an outcome that neither party wanted or contemplated. Come back to the question, or the point I made earlier about your client rings you or emails you and says, what is my legal right? What's my contractual right? What can I do? Can I insist on settlement? And you go back and say, well, yep, reading this particular provision, yes, we can. Right, the client says, go ahead and do it. Please don't fall into the trap of just being the client puppet. Now is the absolute crucial time to utilize all of the hard learned and earned skills about seeing the bigger picture, being the prudent advisor. And I can't stress that enough, because some are coming back to me and saying, my client instructs, or the client says, the client demands. Fine. Have you talked through with your client about the logical consequences of where this might go, not about the immediate result? So again, it's about the bigger picture stuff, factoring in all of those considerations I've talked about. Talk to your client. Consider what their position is. Consider the position of the other side. And for goodness sake, please be nice, courteous, respectful to each other and staff, and of course clients. You want to keep the clients at the end of the day. So that really is the conclusion from me. I apologize if it hasn't answered all your questions. And the end result is we probably can't answer every scenario that is out there. And that's what I'm saying in this slide here. You're trained professionals. Apply the skills, apply the principles. I'll pass over to Robbie. Thank you.
Thank you, Duncan. Look, now I'd just like to move on to some updates on LIN's requirements and process changes. And obviously one of the key areas of change for property lawyers is around the use of audiovisual technology to support remote working arrangements. As Duncan mentioned earlier, in light of the COVID-19 lockdown, our requirements for the use of AV technology for remotely verifying client identity and witnessing A&I forms have been relaxed. So there's always been guidance that supported the use of AV technology. There were originally some restrictions. The key ones were that you had to have known your client for more than 12 months, and you had to have already a copy of their photo ID on file. So those restrictions have been lifted, given the situation that everyone is now in. So it means it's now permissible to use audiovisual arrangements for both new and existing clients, but provided other reasonable steps are taken to verify client identity. So I'll come back to what those other reasonable steps might be. But when using online methods for verifying client ID, it's important to remember some basic rules, and these are already set out in our existing guidance for the use of Skype and other AV methods. So firstly, if you have any doubts as to the identity of your or capacity of your client, then clearly you cannot proceed. If you have concerns that your client may be acting under duress or at the direction of another person, again, you wouldn't want to proceed. And also, if you're not able to simultaneously see and hear your client and also clearly see the document that they're signing, then again, you would want to hold off on the AV witnessing process. And I guess just a general observation, we're all getting a lot more experienced and familiar with the various options for online meetings, myself included. They're actually working very well for us in this time of need, but occasionally you can have some technical glitches with poor audio or sessions dropping out. So again, if your session isn't working while you're trying to identify your client, you need to stop and maybe reset and try and get things working a bit better so you can properly do that verification. So look, back to the question of other reasonable steps and further inquiry. Along with the basic checks of acceptable photo ID that have always been there, and obviously that's your passport or your other New Zealand government issued photo ID, and there's a list of what's acceptable there in our 2018 guidelines. there are some other things to bear in mind. If it's a transfer or a mortgage, you do need that evidence connecting the client to the property. You need to obtain that. That could be the rates demand. It could be the utility bill. It could be the insurance policy for the property. Something that clearly links your client to that property is what's required. And if it's a high-risk transaction, and this is important as defined in our ID verification standard from 2018, further inquiries do need to be made. Again, there's more detail on this in the standard, but there are, and the guidelines that support them. But there are some obvious things that you can do. A common one is just checking the historical view of the title. And if you find that the person, your client that you're Skyping in, looks to be in their early 20s, and when you search the historical view of the title, it's clear that the current registered owner bought the property back in the 1960s, you'd have to be raising some red flags and wondering what was going on there. Other things that you can do are seek to independently make contact with the owner via the physical address of the property. If a power of attorney is involved in the current environment, you might want to seek to make contact with the donor of that power. Seeking additional forms of photo ID. There are other forms of ID that can also be relied on in conjunction with a passport or a driver's license. If you have more of those forms of ID, that might provide you with some further assurance. And there's further information again on all these issues, the definition of a high-risk transaction and options for further inquiry in our 2018 standards and guidelines. Our interim guidance, which we've issued specifically to address the COVID situation, also suggests some additional options. And one useful one is using DIA's online confirmation service. So that allows you to check your client's identity information with government-held data relating to passports and other records. So there's a link to the website for that online confirmation service in our interim guidance there for you. So consider that. Another option that's been suggested is obtaining confirmation from the client's bank that proper ID checks have been undertaken in line with LIN standards. And obviously, in that case, you would want to make sure that you're getting that confirmation and supporting documentation directly from the bank. So look, there's a range of additional steps that you can take to manage risk when remotely verifying client identity. It's particularly important when dealing with a new client and in relation to a high-risk transaction. And there's guidance for you there on that. But above all else, and this applies to a lot of what we've been discussing today, use your professional judgment. In this context, if you're not satisfied as to the bona fides of your client or the transaction, you shouldn't proceed. So look, that's all I wanted to say on ID verification. There is more guidance there in terms of what's been published. Now, moving on, excuse me. The other issue that we've received a lot of queries about lately is whether it's permissible to use digital signatures for A&I forms in the current environment. The short answer to that question is yes. And in fact, that's something that we've been exploring for a little while with various offerings for digital signing systems now starting to emerge for conveyancing. But there are some things to be aware of in this context. And firstly, I'd point you to the Contract and Commercial Law Act 2017. So this provides the generic statutory framework which authorises the use of digital signatures. And this really is your starting point. And the criteria that need to be met in order for an electronic signature to be reliable is usefully set out in section 228, subsection 1 of the Contract and Commercial Law Act. And I'll just briefly read out those provisions because they're it's fairly quick. They're there for you to have a look at, obviously. But firstly, the criteria are that the means of creating the electronic signature is linked to the signatory and no other person. The means of creating the signature was under the control of the signatory and no other person. Any alteration to the electronic signature made after the time of signing is detectable. And where the purpose of the legal requirement for a signature is to provide assurance as to the integrity of the information to which it relates, it obviously applies in the context of conveyancing transactions. Any alteration made to that information after the time of signing is detectable. So these principles, this set of criteria here are all geared towards ensuring that there's integrity behind the use of electronic signatures when you're using them for important documentation like property transfers and A&Is and the like. So that really is your starting point. In practical terms, what this means is that the digital signature system that you're using, it must include secure audit logs and a record of the signatory, what they signed, when they signed it, and that information must be available for audit purposes. At the end of the day, to protect you, you must be satisfied that this digital signing system you're using, or the electronic signature system you're using, has sufficient integrity to enable you to rely on that for the purposes of making your Land Transfer Act certifications. So just to state the obvious at the end here, just having an image of a signature cut and pasted into a document would not be sufficient. Obviously something like that would be easily forged. So look, just a few pointers there on the use of electronic signatures. It is another option in the current environment, and there's some guidance there in our interim guidelines around the requirements for that. Now moving now to some other process changes in light of the COVID lockdown. Duncan's actually already referred to the issue of statutory declarations. The question of whether statutory declarations can be taken remotely has come up, and the opinion that the property law section of the New Zealand Law Society have provided is very useful in that regard, and I can confirm that LINZ will accept statutory declarations taken in that manner where they're required for land transfer purposes. So if you haven't already seen that guidance, have a look on the Law Society website and have a look at that opinion on remote statutory declarations. Just a note on caveats here and caveat lapsing. As we've just recently published, LINZ is in fact putting a hold on lapsing applications for the time being in terms of any new requests. The rationale for that is probably self-evident. In the current environment, where it would be unreasonable, I think, to expect the recipient of a caveat lapsing notice to necessarily be able to take the appropriate actions to sustain a caveat within the prescribed statutory timeframes. Given that, we think the sensible thing to do is to just put those on hold for the time being. And obviously we'll revisit that as circumstances change. There's more information about that and also how we're handling lapsing applications that we're already underway in the information that we've published, so that's there and available for you. Another note here, maybe it's an obscure point, but it's one that's already come up for us. Applications to withhold landowner details under Section 42 of the Act. You might remember these non-disclosure provisions that allow landowners to have their title ownership details hidden, if you like, in cases where their personal safety is at risk if that information is available. What we've decided to do here is that although ordinarily we would want a statutory declaration supporting the evidence of the application to be provided, in the current environment we've dropped that requirement. We will accept applications without statutory declarations. They still have to set out the grounds for the application, why the applicant's personal safety is at risk, but they don't need to be supported by a statutory declaration. And again, because we wouldn't want that to be a barrier to someone gaining this protection where it's urgently needed. Another point there, LINZ's compliance reviews and audit processes are on hold. We're very conscious that in the current environment, everyone is busy and has their hands full with a whole range of urgent matters and working through the kinds of settlement issues that Duncan was just traversing in his presentation. We don't think it's reasonable to be also asking you to engage with our audit process at this time. So we have put that on hold for both new compliance reviews and those that were already underway. That will obviously resume when we get back to more of a business as usual environment, but on hold for the time being. Just a note on our Land Online services. As you will have seen, the system, Land Online, is obviously available with the usual hours of access and support. We've also just recently released a new web search service which allows access to Land Online data without the requirement for a digital certificate. It's only there for search purposes. This is an enhancement to the Land Online system that we've been working on under the STEP program for rebuilding the Land Online technology. We've brought that forward now because we see that this additional service will be of benefit to people in the current environment, particularly if they're having technology issues with Land Online or with digital certificates. And I guess as an observation, one of the great benefits of an online system is that we're able to continue these services at a time like this. And I was reflecting the other day that had this occurred back in the days of the paper environment, and I'm old enough to remember that, we would be in a completely different situation. Our registration system would effectively have ground to a halt. So I guess we're fortunate that the system is online and available. Worth noting also that we now have about 85% of e-dealing transactions registered in a fully automated way, and that work is just continuing. We do, however, have some challenges with digital certificate renewals, which I would acknowledge, and I apologise for that, because I know the last thing people need is another technology hassle at this time. That was problematic for us because the digital certificates have to be issued from a secure on-site system within our Land Online offices, and with the lockdown that obviously became very problematic. I'm pleased to say that we now have the ability to issue digital certificate renewals, and we are working through that now as quickly as we can. There's a bit of a backlog there, so please bear with us, but we will be getting on to your DC renewal if you're in that situation. Look, I'd also like to apologise to anyone who was affected by the replacement of the Land Online Citrix receiver over the last weekend. Don't ask me to tell you in technical detail what the Citrix receiver is, because I would quickly get out of my depth. It did need an upgrade though. What we didn't anticipate was that would also require some users, not everybody, to upgrade to a new version of Citrix. When we opened for business again at the beginning of this week. It wasn't anticipated. If we'd known that was the case, we certainly wouldn't have gone ahead with the receiver upgrade. There's more information about this on the LINZ website in terms of how to upgrade to the new version of Citrix if you need to. I think Duncan was a victim of this earlier in the week, so again, apologies to Duncan for that. And look, just another technical note here. If anyone is having difficulty converting images to TIFF format for submission to Land Online in the home office environment, where you don't have your usual scanners and whatnot, there is some guidance on this, which we'll be updating on the LINZ website to provide a bit of help with that. And just some final notes on LINZ services. Because our offices are closed during the lockdown, we are in fact unable to process postal correspondence or paper dealings. Effectively, they're just in abeyance at the moment. So please use our electronic channels through Land Online or our contact centre, those usual channels. If you did happen to have written to us using post on an urgent matter, don't expect a quick response on the paper post. Resubmit your request or correspondence electronically, and we'll be able to get to it. The good news is that all our staff are now working remotely from home. We're able to set our staff up to operate in that way, to access land online. So we are able to maintain operations for most of our land registration work. And this includes complex subdivision work and new title work. However, because of the limitations of the home office environment, there are some constraints on our ability to serve notices, which will delay the processing of some dealings only where those notices are required. And look, just a final note, our contact centre is operating, so if you do need support, you can access it through those usual channels. So I think at this point, I'll bring my part of the presentation to a close. We do have plenty of time for questions. And we're very keen to hear about your queries if they haven't already been answered by what you've just heard. So I will now open the floor to questions.
This is going to be the fun part for us all. During Robbie's part of the presentation, I've had the pleasure, shall we say, of working through a number of the questions that have come in. As I say, we've already now received hundreds of questions, and what I'm going to try and do is address the general tenor of some of the ones that are there that have come in. One of them is, can we charge clients for the extra work? My answer to that will be probably if your client feels you've added value. So certainly this has been foisted upon us, and similarly with what happened in the Christchurch quakes, huge amount of additional work was required. I guess it really is your discretion as to whether or not you feel justified in charging at all, a discounted rate, and also talking to your client about, be upfront. You do realize this is complicated. We're going to have to spend X number of more hours. Are you happy with that? Because it is all about expectation management to minimize a complaint about your cost later. The last thing you want to do is just carry on at your rack rate, accruing time, and then ambushing the client at the end. That's asking for trouble. So all I would say is there is no reason why you shouldn't be charging for this extra work, but for goodness sake, liaise with your client first. That's simple. Another question, very valid question, is why level 2 in the guidance that the property law section sent out? You'll recall that we said that settlement should be deferred to the 10th working day after we are back to alert level 2 or below. That went out last week. The executive had discussions and quite a bit of debate to and fro whether that should be level 3 or level 2. At that time, the best information was that for full freedom of movement that would facilitate people moving house, level 2 was the safe option. There is still some debate around that. Level 3 is still quite restrictive. So that is why we took the conservative approach and went for a level 2. I am aware of a number of arrangements that have been made between parties to say as soon as it comes down to level 3, they have agreed between themselves settlement will occur. So again, it is talking to your client, assessing what has to happen, physically what they have to do, what the options are going to be. The other thing that we don't know, or two key things, we don't know the duration going forward. And also, we don't know if possibly there may be a geographical split on alert levels. For example, if we look at Wuhan, they are now allowed to move freely, but not outside that region. So who knows what the future will hold? Perhaps if there are certain regions of the country geographically that have eliminated all cases and no new cases, it may well be, well, that region can be dropped. I don't know. This is just me thinking out loud. So going forward, we just don't know what's going to happen. So at the moment, our best advice still remains at saying level 2 to be fail safe. If your clients agree and the other side agrees that you want it to be level 2 or level 3, it's up to you. Another question we have, can we just cancel on finance or cancel on a clause because of COVID-19? There's various conditions that may be in an agreement. If it's just finance, I do think under the terms of the agreement that all things must reasonably be done to fulfill the condition. And I do think that is still appropriate. But for example, if the bulk of your purchaser client funds are coming from KiwiSaver that's been in an aggressive fund that perhaps has halved in value, may not be able to proceed. So you can then legitimately look to cancel on the finance. Just also want to note, seems to be a myth out there that you always have to provide evidence to the vendor of failure for finance. Last 5 words of clause 9, 9.1, basically 9.12, upon request by the vendor. So that should only occur if the vendor feels that someone has just changed their mind. So if it's subject to finance, I think proper application needs to be made. And then if you are challenged, you need to be able to provide proof. Other clauses such as property inspection report, building inspection report, that may be more difficult. If the client still wishes to proceed, maybe look to get an extension of that time frame. Or clients may choose to leave it running on. Again, it is about what your client wants to do. Other one, can a client just withdraw from an unconditional contract? No. I don't think there's any justification or basis for that. The fact that the purchaser client may be under financial hardship or duress doesn't of itself give rights to negating the contract. Having said that, if your purchaser client says, my business is now dead, I've got no income, I will not be able to proceed, and I won't be able to effect settlement, go to the other side, go to the vendor and explain the situation and see what they want to do. Possibly the vendor may believe finance in, who knows? Again, talk to the other side, talk to your client, try to reach a deal that works for both parties. So that's just some of them that I've touched on. I'll pass on to Robbie to see if there's any he likes the look of.
Duncan, I actually briefly dropped out and have now lost the questions, so you might be able to cherry pick some curly ones for me and just throw them my way.
I think possibly if you can go to, you should be able to scroll up and bring them back up from the chat screen at the bottom.
Yeah.
I'll just carry on with a couple of others.
Yeah.
Where we got?
Yeah, sorry, I'm only getting the questions that have come in since I relogged in.
Okay, you can have those ones then. If we see, yeah, someone has also raised just about the various regions and interdependent cross-region ones. Again, that's around the issue of someone is selling in Tauranga, buying in Christchurch. Again, it's about that physical movement of people, prohibited at the moment, obviously, no domestic travel. So it would be a case of, well, do you still go ahead and settle? Is the vendor happy to remain in the property on a rental arrangement? So again, similar to the things we discussed earlier.
Duncan, I see that there's quite a few questions that were coming in around digital certificates and so forth. Obviously touched on that in my presentation, but if people are in a situation where they've been waiting for a while to have their digital certificate renewed, just to provide some more context around that, because of the challenges that I mentioned earlier with needing to access that secure system on site in Lynn's offices, there was a period of time when we weren't able to do renewals. So there is a bit of a backlog that we're working through. We do now have our staff working hard on that to clear that as quickly as possible. So again, I just sort of reiterate, we are issuing those digital certificates. Please bear with us for the time being. Our web search, our new web search service, which some people have commented on there too, and the questions coming in saying it's working well for them. That's an alternative option. Obviously, doesn't allow you to proceed with the certifying of dealings and so forth, but for searching purposes, you could access that without your digital certificate.
Thanks, Robbie. One of the other questions is around situations of tenanted properties where the tenant notices have just been given or going to be given, and obviously with various statutory and government announcements around residential tenancies, that is tricky. So I think that would be an obvious case if someone was taking over, purchasing a rental property for their own occupation. Clearly the tenant basically can't be booted out. So again, talk, negotiate, look at an appropriate extension of time. One of the other ones that just come through now is what if a client's business has been affected, equity used up, etc., relevant to cancel finance? Again, I really come back to the point of if the agreement is still conditional upon approval of finance and it is very clear that the bank will not be approving finance, then again, that should be a legitimate reason to cancel for non-availability of finance, bearing in mind that if the vendor seeks evidence of the inability to obtain finance, you've got some robust documentation to support that. So again, it's about just looking at the factual situation and how that will work.
Duncan, just some additional comments there in response to the AV client ID methods. In terms of process around that, one of the other things to bear in mind is just how you record the manner in which you verified your client's identity and witnessed the ANI form. And there's obviously the ANI form itself needs a slight adjustment. I think it's section 5 of the ANI form, which refers to in-person witnessing. That should be updated to reflect the fact that you're using the audio-visual methods and have done that remotely. Another thing that's been suggested, which I'd encourage, it's not essential, but it's certainly useful and you may find it so, is just to take a screenshot at those critical times in terms of viewing your client, viewing their photo ID, and keeping a screenshot as part of your record of how you undertook those important steps.
Thanks, Robbie. And just a couple of other ones that have come through. One was, can over 70s settle and move in lockdown as some sort of exception? I think that would probably be unwise unless they are in an unsafe position, and they are, as we know, the high-risk category. The only times that I'm aware of people being able to move is in a physical violence or threat situation where they may be, for example, under women's refuge, taken to a safe house. That is normally done under police supervision or police escort. So again, it is really a case of if someone is at risk of physical harm, then that would be the justification, and the only justification, and normally would be need to be of sufficient gravity to have involved police on that front. We've got a few others in here now.
Duncan, there's a question here about digital signing that I might just
you can have that one, Robbie. You're welcome.
Yep. So someone's asked a really good question. Can a client sign a document by using a stylus on a laptop to do it? Look, in response to that, I'd say let's go back to those the the principles that I was referring to earlier in relation to electronic signatures, and in particular the criteria that's set out in the Contracts and Commercial Law Act. And you'll remember when I touched on that in my presentation, there were some key things there that you need to be satisfied your digital signing system can do, in terms of maintaining a clear audit trail and record of the identity of the person who's providing that signature, what was signed and when, and other requirements around the ability to detect any changes that was made to what was digitally signed. And again, that's all about ensuring the integrity of that digital signing process. So in terms of, can a stylus on a laptop be used to do so? Well, theoretically, yes, but only if the system that supports that provides those audit trails and records and has the kind of integrity that's envisaged in the criteria set out there in the Contract and Commercial Law Act.
Thanks, Robbie. A couple of the ones that I think are probably quite pertinent is not necessarily in relation to settlements, but in relation to bank documents. I've got a situation where we've got urgent bank documents for a client in business, just needing to obviously do a top up. So we're doing variations of mortgage, increasing priority amounts, etc. And the other one that's come up is guarantees, bank guarantees to link with companies, etc. So I just really want to touch on a couple of those things. In relation to a set of bank documents that has loan agreement, etc., usual stuff, generally speaking, the loan agreement, and for that matter, tax statements and OIO statements don't require witnessing as such. I do, however, strongly recommend that you will be doing a video link with your client for signing the ANI in any event. And I would strongly advise you to stay on that video session and watch the client sign the other documentation. So I think you then, in those circumstances, need to do a pretty good file note to say that you've seen the client sign, obviously appropriate explanations of the various documents as you go through. So that will just protect you down the track if there's some sort of dispute or argument in relation to valid execution. Guarantees, again, that's one that I suggest that you talk to the relevant bank about. I am aware historically that where a solicitor has not been present to actually advise, the bank has accepted a full written explanation to the client summarising their rights, or in some cases a video conferencing, and then have someone else, maybe who's in the bubble, actually witness them sign it, but then the lawyer doing the guarantee certification makes modifications to that, saying, I wasn't present and saw them, but I've explained all these things to them. I'm aware that some banks will accept that, but again, if there are guarantees required to give effect to certain transactions, liaise with the particular bank and put forward the proposal that you have. One of the other ones is around the issue of witnessing of EPAs and wills. There are have a look at the Wills Act. Not exactly riveting reading, I know, but actually have a look at that. And there, even if it's not on all fours with the strict requirements, you would still be able to do potentially an application for letters of administration with will annexed, even if it's not completely valid. Problem we have, of course, for wills, you may say, I'll email it through to the family and they can sign it and witness it. Fundamental problem, as you're aware with that, is any witness who's a beneficiary, or a beneficiary is a witness, it invalidates the gift to that particular beneficiary. So that's not practical. So again, working with Ministry of Justice on options for that may require some emergency amendment, even on a temporary basis. So again, grateful for the discussion and time that we're having with MOJ on that. Similarly with enduring powers of attorney, There may be elderly ones who are in desperate need of that. Again, watch this space. We will be communicating with you again as soon as we have answers from MOJ and on the same page. Thank you. Robbie, do you have anything there that you've picked up?
Yeah, there's another good question here. Is the period for compliance with LIN's requisitions on a dealing likely to be extended in the COVID-19 environment? And the answer to that is yes. That's something we're actually looking at the moment, and we'll be publishing some more guidance around shortly. In the meantime, it obviously just makes sense to be providing latitude around that. If you've got particular concerns in relation to a dealing and you need an extension, just get in touch with our contact centre folk.
Just looking through it, a few more of them now. Basically, what happens if there's a full standoff and the parties simply cannot agree? Again, that's an undesirable position for everyone. It's not helpful, and I think parties who are just sticking belligerently to the letter of the contract may regret that down the track. And that's all about the bigger picture, talking to the client. If you've done everything you possibly can to try and negotiate, it's very important that you obviously have really good file notes, retention on your file of relevant exchanges of emails, etc., to show you've taken all reasonable measures. And that will be probably playing a very pivotal role down the track if it regrettably ends up in court. So it's just a case I'm getting the feeling that some are just at the end of their tether, pulling their hair out because they have tried everything to negotiate and the other side is saying no. If you're the lawyer saying no on behalf of the client, I think maybe go back, talk to the client and explain that bigger picture in light of what we talked about in the earlier slides, because protracted litigation is not a place that anyone really wants to be. I'll pass back to Robbie.
Thanks, Duncan. There's another question here on digital signing. Will LINs accept other documents that need to be signed and witnessed using the ADLS web forms digital signing, e.g. unit titles of exchange of rules certificates? Look, I think in principle, yes. I'm not sure whether that package is actually set up to support the signing of those kind of documents, but were that to be the case, we would certainly be comfortable with that.
Thanks, Robbie. Another one here just in relation to commercial leases. It's probably important just to address the 27.5 is obviously just in the current ADLS lease form. There are a raft of different forms of lease out there, especially mall leases are markedly different. There's BOMA leases, there's all sorts of variations. So it's a case of dusting off those, getting them from clients, and really reading through and seeing what the legal position is. One of the questions was, is the Law Society seeking an opinion on what is a fair proportion? Unfortunately, it won't be like a Nike cap. One size will not fit all. So it is a case of there will be a raft of different scenarios where what is fair for one will not be fair for the other. So again, I come back to that slide in relation to commercial leases, negotiate, 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 because a fair proportion is probably ultimately going to be seen as a subjective test from an objective point of view, which is entirely unhelpful. So it really is going to come down to what is reasonable in the circumstances, looking at the position of the tenant and the position of the landlord. So I'm sorry, I don't think there's probably going to be a lot of value in obtaining a legal opinion on the position of what is fair and reasonable. It will vary depending on the factual situation. Another one we've just got here is business interruption insurance on contracts. Again, many people will be looking, especially tenants and landlords, will be looking at their their insurance policies. Now, post-quake, a lot of insurers did extensive reviews of what's covered and what's not, and there are a lot of tick opt-in, opt-out options on insurance policies. And this is going to be a very relevant one, an important one about business interruption, and whether during a state of emergency it applies. Some contracts of insurance exclude cover if there's a state of emergency. So again, it is a case of becoming familiar with what the wording is on the particular client policy. And again, the answer it will depend on what it says. Yeah, abatement, another question there, fair abatement of the percentage, etc. Forced to close, but still with equipment. So the argument for the landlord will be, well, yep, you can't access it, but we're still keeping your plant and equipment safe and dry and secure in our premises. So why should there be a full abatement? Again, it comes down to the circumstances. I'd be very careful and reluctant to issue notices in termination. You may subsequently find that it was maybe a wrongful termination of the lease, and you may actually be losing a whole lot of rights to terminate. So again, all I can say is look at the form of lease you're using, even talk to your client as well about business interruption insurance, what cover they have. I'll pass back to Robbie.
Thanks, Duncan. Yeah, there's a good question here. What happens if the clients do not have a scanner and a printer at home to receive or return the documents? And I guess in this environment, everything becomes very heavily dependent on the technology and the ability to work remotely. And I suppose at the end of the day, if the client just doesn't have the technology to be able to do that, or say more fundamentally an internet connection, that might be a case where the transaction just has to be delayed. But if the issue is just scanner and printer, there has been some thinking around that and some quite creative suggestions in terms of writing long form authorities and taking a photo and emailing a photo of the signed authority back to the lawyer and other such options. Which again, if they meet the fundamental requirements and achieve the desired result, those options are potentially there. That's something that I think too we're just in the midst of providing some further guidance and examples around. So keep looking at our website and the information that's coming out from the Law Society that may provide a bit more around that.
Thanks, Robbie. We've got a couple of others in, one in relation to the final code compliance is just issued, and that was obviously the trigger for settlement, probably similar to issue of new title scenario. Again, same situation, because of lockdown, purchaser can't move in. Are they still required to settle? Again, it's the same sort of issues there. Presumably, one would have had all their finance sorted if one knew that title had issue and that the production of the final co-compliance certificate was imminent. Probably things should have been in place already. So again, it comes down to the risk does the client want to take of not settling in that scenario, and again, talking through the possible options, because we don't know at the end of the day how long this is going to be and what the financial implications are for that client. Some clients are saying, right, we know we can't move in, but we don't want to take the risk or hassle, we'll just settle it because we're in a position to settle it. Another question, what if the purchaser doesn't want to confirm on finance, as there could be a large time frame between confirmation and settlement, and financial circumstances could change, i.e. loss of income? Yes, a very, very valid concern. And if you haven't already confirmed finance, I think it's probably prudent to discuss with the client what their source of income is and the likelihood of detrimental effect and impact going forward. If it's very clear that they may have significant reduction or problem with ongoing income, that would be justification to go back to the bank and say, hey, this is a change. Can we still have finance? They'll probably say no. there's your protection. Some are saying, well, hang on, let's go ahead and settle now because I might not have my income, so I want to get it done and dusted while the approval's still there and the funds are available. Yes, but word of caution, is that really prudent? If the client isn't going to have the means to service that loan, what is the inevitable result? Which is the lesser of two evils? So again, it's about being prudent advisor to your client, because I'm aware of some that say, right, we need to settle now, we need to draw down that loan because I'm not going to be able to pay for it later. Yes, and then what's going to happen? Talk the scenarios through with your client, look at the bigger picture. I'll hand back to Robbie.
Thanks, Duncan. A creative one here. Can your neighbour witness from a distance? So I assume this is referring to witnessing the signing of an A&I form. Look, I would suggest on this, don't go down that track. If your neighbour's not in your bubble, and presumably they're not, you shouldn't be setting up an interaction which could inadvertently lead you to closer contact than you should be having, given the COVID lockdown and all the advice there is around that. I would question whether, from a few meters away, whether you could properly see what was going on in terms of the person signing the A&I form and so forth. And also you might question whether the neighbour's actually the right person to be properly undertaking ID checks and so forth for the purposes of completing an A&I form. So my recommendation would be don't go there.
Thanks, Robbie. It's got another one in for residential properties, rental properties, abatement situation where landlords receive mortgage relief. What should happen in that scenario? Well, again, it comes down to the circumstances where, if we go back to first principles and what we talked about earlier, if it's a rental property that you're continuing to have the same tenant, there's probably no reason to not settle, in my view, all other things being equal. The fact that a landlord may get a mortgage holiday doesn't actually probably change a whole lot, and often that's going to be just a deferral of that interest, not a complete write-off of that interest. So again, if it's a rental property, probably look to settle. There probably has to be pretty good grounds and basis to not settle on it. I think we probably have time for maybe one more question. I'll hand back to Robbie.
Thanks, Duncan. Question here about attaching TIFF files. Please advise on attaching TIFF files to an e-dealing. I'm probably not the best person to give a detailed technical rundown of that over the webinar, but again, we are looking at providing some updated guidance on that, geared towards the fact that people are working in the home office environment. So that will be published, and I'll also make sure there's a link to that provided through the next property law section e-bulletin. The other question that we've got here is, could a solicitor and someone else in the solicitor's bubble remotely witness with a file note or statutory declaration? I think the response to that is yes, provided that you follow the guidance that we've just traversed over the course of this presentation, and obviously the published guidance that supports that. Thanks, Duncan.
Thanks, Robbie. I just really want to probably in wrapping up say, I hope that some of the questions have been answered. Apologies that we haven't been able to get to all of them. Please don't shoot the messenger if the answers weren't the ones you wanted, and if we haven't covered everything. And again, the plea that I said from the outset, we are under huge pressure. Myself, I'm still trying to run a practice, keep clients happy, as you are. We don't have the capacity to deal with hundreds of your scenarios, unfortunately. We would love to. Please think about applying the fundamental principles. Talk to your client, look at what their situation is, look at what they want, negotiate with the other side. I mean, if that's the parting message I can give, that's really all I can offer you at this stage. Property law section will continue to give updates and opinions and work with the government departments and communicate with you as and when we have updates. Thank you, and I'll hand back to Robbie.
Thanks, Duncan, and thank you all again for attending this webinar. Again, I hope you found the content useful. As Duncan has said, it won't have answered all the questions. These are challenging times, but we certainly will do our best in terms of the guidance that we're publishing and the work that we're doing in conjunction with the property law section to make sure that there's as much useful information as there can be out there and available for you. And if all else fails, go back to first principles. Think about the underlying principles that govern what you're doing, and apply your professional judgment. So all the best, and goodbye.